A landmark federal court ruling in January 2026 has just put USCIS's entire EB1A adjudication method under serious legal challenge. In a case called Mukherji v. Miller, a Nebraska federal court ruled that the two-step framework USCIS has been using to evaluate EB1A extraordinary ability petitions may be legally flawed. This is not a minor procedural complaint. This is a direct challenge to the very foundation of how your EB1A case is being judged right now. And if you're someone who is currently preparing an EB1A petition, has already filed one, or is planning to file your I-140 in 2026, what I'm about to break down in the next 15 minutes could fundamentally change how you approach your entire case. This is not speculation. This is not rumor. This is grounded in an actual federal court decision, documented USCIS data, recent request for evidence trends, and adjudication pattern shifts that are already affecting real EB1A applicants right now in 2026. Stay with me, because by the end of this video, you will know exactly what this court ruling means, what else has changed with EB1A approvals, why it matters, who it affects, and what you need to do before you file a single page of your EB1A petition. Welcome back. My name is Alexandra Pierce. I'm a senior immigration analyst and consultant, and on this channel, I break down complex immigration developments, like this groundbreaking EB1A court ruling, into clear, fact-based analysis you can actually understand, without the legal jargon, without the panic, and without the noise. Everything you hear on this channel is grounded in policy, regulation, court decisions, and documented USCIS guidance. We don't do rumors here. We do research. Now, with that said, let's get into what is actually happening with EB1A approvals in 2026, starting with this court ruling that could reshape the entire landscape. Let's start with a quick foundation, because understanding what the EB1A green card actually is makes what's happening to it and why this court ruling matters far more significant. The EB1A, Employment-Based First Preference Extraordinary Ability, is one of the most powerful immigration pathways available under U.S. law. It is authorized under the Immigration and Nationality Act. And what makes the EB1A unique is this: it does not require a job offer. It does not require employer sponsorship. You can self-petition, meaning you file your own I-140 and make the case that you, as an individual, are so extraordinarily accomplished in your field that your presence in the United States benefits the nation. That's a high bar for EB1A approval. And it's supposed to be. USCIS defines extraordinary ability as a level of expertise indicating that you are one of the small percentage who has risen to the very top of your field. To meet that EB1A standard, you must satisfy either proof of a major internationally recognized award, like a Nobel Prize or an Olympic medal, or, more commonly, you must meet at least 3 of 10 regulatory criteria. Those 10 EB1A criteria cover things like awards, published material about you, original contributions of major significance, scholarly articles, critical employment in distinguished organizations, high salary relative to peers, and more. Now, here's where this gets critical. For years, USCIS has used what's called a two-step framework to evaluate EB1A petitions. This framework came from the 2016 Matter of Donisar decision. Step 1 asks, does the applicant meet at least 3 of the 10 regulatory criteria? Step 2, the final merits determination, asks, even if they technically meet the criteria, does the totality of the evidence prove they are truly extraordinary? This two-step framework has been the backbone of EB1A adjudication for nearly a decade. And in January 2026, a federal court in Nebraska essentially said this framework may be legally flawed. Let me explain what happened in Mukherji v. Miller and why it matters for every EB1A applicant watching this video. In this case, the petitioner had their EB1A denied by USCIS. Like many applicants, they technically met 3 of the 10 regulatory criteria. But USCIS used the second step, the final merits determination, to deny the case anyway, arguing that the totality of evidence didn't demonstrate extraordinary ability. The petitioner challenged this denial in federal court, and the Nebraska federal court made a significant ruling. The court found that USCIS's application of this two-step framework, particularly how they use the second step to deny cases that have already met the regulatory threshold, may exceed the agency's statutory authority. In other words, the court suggested that USCIS may be adding requirements that Congress never intended when it wrote the law. Now, let me be clear about what this does and doesn't mean. This ruling applies directly to this specific case. It does not automatically overturn USCIS policy nationwide. Other courts may rule differently. This will likely face appeals and further litigation. But here's why this matters right now. This ruling creates legal precedent that immigration attorneys can cite when challenging EB1A denials. It signals that federal courts are willing to scrutinize how USCIS is applying its own standards. And it puts USCIS on notice that their adjudication practices are being watched and challenged at the highest levels. For EB1A applicants in 2026, this creates both uncertainty and opportunity. Uncertainty because the legal landscape is shifting in real time. Opportunity because if your case is denied, there may be stronger grounds for appeal than there were 6 months ago. But here's the reality on the ground right now. While this court ruling works its way through the legal system, USCIS adjudicators are still applying heightened scrutiny to EB1A petitions. The day-to-day experience for applicants has not changed overnight because of one court ruling. Based on USCIS statistical data and adjudication trend reports tracked through late 2025 and into early 2026, the EB1A is experiencing a notable tightening in how officers evaluate petitions. Let me break down what that actually means for your EB1A application in concrete terms. The EB1A RFE rate is climbing. An RFE is a request for evidence. It means USCIS looked at your EB1A petition and said, "This isn't enough as submitted." Over recent adjudication cycles, immigration attorneys and analysts have documented a significant uptick in RFEs being issued for EB1A petitions, particularly in categories like tech, business, and entrepreneurship. If you're applying for the EB1A green card in these fields, you need to pay close attention. The interpretation of major significance for EB1A has tightened considerably. One of the most common EB1A criteria applicants rely on is demonstrating original contributions of major significance to their field. In recent years, USCIS officers have been applying a stricter lens to what major actually means for EB1A approval. And here's what many applicants are missing in 2026. It's no longer enough to show that your work is significant within your academic or professional community. USCIS is increasingly looking for what I call the U.S. impact factor. What does U.S. impact mean? USCIS wants to see evidence that your contributions have had or will have a direct, measurable impact on the United States. This could be impact on the American economy, impact on U.S. technological advancement, impact on American public health, national security, education, or industry. A high citation count alone? Increasingly insufficient, unless you can show those citations led to real-world applications in the United States. Publications in respected international journals? Not automatically enough, unless you can demonstrate that American researchers, companies, or institutions have built upon your work. Social media reach? USCIS has been deeply skeptical unless that influence translates into tangible U.S. outcomes. This is a subtle but critical shift in how EB1A petitions are being evaluated. The question is no longer just, are you extraordinary in your field? The question has become, are you extraordinary in ways that benefit the United States? The final merits determination for EB1A is being applied more rigorously than ever before, which is exactly why the Mukherji v. Miller ruling is so significant. As I explained, USCIS uses the final merits determination as step 2 to deny cases even when applicants have technically met 3 or more criteria. The Nebraska court ruling challenges whether this practice is legally sound, but until that ruling forces broader policy changes, USCIS adjudicators are still using this second step aggressively. This is what many EB1A applicants are completely misunderstanding right now in 2026. Meeting 3 EB1A criteria is the floor, not the ceiling, and USCIS is making that clearer than ever through its EB1A adjudication behavior. Court challenges notwithstanding. Premium processing timelines are not protecting your EB1A from scrutiny. Even EB1A applicants using premium processing, which expedites the timeline to 15 business days, are receiving RFEs and denials at rates consistent with the broader trend. Paying more does not mean a more favorable EB1A review. It means a faster one. And if your EB1A case isn't strong, you'll get that answer sooner. Let me bring this EB1A situation to life with a realistic example, not a specific person, a composite of the kinds of EB1A cases that are showing up across the immigration attorney community right now in 2026. Meet Priya. She's a data scientist with a PhD from a respected European university. She's been working in the United States on an H-1B visa for 4 years. She has 5 published research papers, 2 of which have been cited over 80 times. She's received an award from her professional association. She's spoken at 3 industry conferences. She earns a salary that places her in the top 15% of her peer group. By almost any reasonable measure, Priya is accomplished. She seems like a strong EB1A candidate. And when she sat down with her documents, she and her initial reviewer counted at least 4 EB1A criteria met. She filed her I-140 petition in mid-2025 with confidence. She received an EB1A RFE 3 months later. The RFE challenged whether her award was sufficiently distinguished for EB1A purposes. It questioned whether her citations reflected major significance as opposed to routine scholarly engagement. But here's the part that caught Priya off guard. The RFE specifically asked for evidence demonstrating how her research contributions have impacted or will impact the United States economy, technology sector, or scientific advancement within America. This is the U.S. impact requirement I mentioned earlier. Priya had strong evidence of her global academic contributions, but her original petition didn't clearly articulate how her work benefits America specifically. She had citation counts from researchers worldwide, but the RFE wanted to know which American institutions have applied your findings, which U.S. companies have benefited from your research, how has your work advanced American interests in your field. Priya is not a weak EB1A candidate, but her petition, as originally submitted, didn't tell her story in the language USCIS is now demanding for EB1A approvals in 2026. The evidence of global excellence was there. The narrative of U.S. impact wasn't. She responded to the EB1A RFE with a restructured narrative. She obtained letters from American researchers who had built upon her work. She documented how her algorithms are being used by 3 U.S.-based technology companies. She included evidence that her published methodology is now taught in 2 American university graduate programs. Her case is still pending, but her RFE response was dramatically stronger because she understood what USCIS is actually looking for. There's one detail most EB1A applicants are missing. The EB1A is not just an evidence checklist. It is not just about proving you are extraordinary. It is a legal argument that you are extraordinary in ways that serve American national interest. And in 2026, that argument, with explicit U.S. impact evidence, needs to be airtight before you submit a single page. Let's talk about the institutional forces driving this shift in EB1A adjudication, because understanding the source matters for anyone applying. This is not a single new rule affecting the EB1A green card. There is no executive order that specifically changed the EB1A standard. What is happening is a combination of adjudicatory culture shift within USCIS, evolving policy manual interpretations, and now, with Mukherji v. Miller, active judicial scrutiny of those practices. USCIS adjudicators who review EB1A petitions operate under the agency's policy manual, maintained by the Department of Homeland Security. The relevant EB1A guidance lives in Volume 6, Part F of the USCIS Policy Manual. That manual has been updated and refined over time, and the current interpretive environment reflects a heightened emphasis on evidentiary quality over quantity, and increasingly on demonstrable U.S. benefit. The broader immigration enforcement posture of the current administration has created an environment where USCIS adjudicators reviewing EB1A petitions may feel additional institutional pressure toward rigorous review. This is not unique to any one administration. Scrutiny levels tend to shift with policy priorities. But right now, in 2026, the adjudicatory environment for discretionary petitions like the EB1A is one where you cannot afford to submit a marginal case and hope for the best. At the same time, federal courts are now actively questioning whether USCIS has overstepped its authority. The Mukherji versus Miller ruling in Nebraska is the most significant recent example, but it's part of a broader pattern. Courts in the Ninth Circuit and Fifth Circuit have also weighed in on EB1A adjudication standards, with some rulings favorable to petitioners and others upholding USCIS discretion. What this creates for EB1A applicants is a landscape in flux. The law itself hasn't dramatically changed, but how it's being applied is being challenged from multiple directions. USCIS is applying stricter standards. Courts are questioning whether those standards are lawful. However, and this is important for anyone considering the EB1A green card, this pathway has not been closed. The EB1A remains one of the most valuable green card options available, particularly for foreign nationals who cannot easily find employer sponsorship or who face decade-long backlogs in employment-based categories like EB2 or EB3 due to country of chargeability. The door to EB1A approval is open. The standards at that door are higher and more complex than many applicants realize. But understanding those standards, including the new emphasis on U.S. impact and the legal challenges to USCIS's framework, gives you a strategic advantage. Let me be specific about who needs to pay close attention to this EB1A update. If you're directly affected by these EB1A changes, anyone who has filed an I-140 under the EB1A category and is awaiting adjudication should monitor their case carefully and be prepared to respond to an RFE with strong, targeted evidence, not just more volume. Your RFE response should explicitly address U.S. impact if that wasn't clear in your original filing. Anyone who has already received an EB1A denial should consult with an immigration attorney about whether the Mukherji v. Miller ruling or similar precedents might strengthen a motion to reopen or a federal court challenge. Anyone currently building an EB1A petition should reassess whether their evidence meets not just the quantitative threshold of 3 criteria, but the qualitative standard USCIS is now demanding at the final merit stage, with particular attention to documenting U.S. impact. If you're indirectly affected, H-1B holders who were banking on EB1A as a self-petition route to bypass employer-dependent green card timelines need to evaluate their timeline assumptions and evidence strength. EB2 NIW applicants, National Interest Waiver, should note that many evidentiary standards overlap with EB1A. The same adjudicatory tightening and emphasis on U.S. national benefit observed in EB1A petitions applies even more directly to NIW cases. O1A non-immigrant visa holders transitioning to EB1A green cards should understand that O1A approval does not guarantee EB1A approval. They use similar but legally distinct standards, and USCIS applies a fresh analysis to your I-140 regardless of prior O1A adjudication. This EB1A update could affect you even if you haven't started your petition yet, because the earlier you understand the current EB1A standards, including the U.S. impact requirement, and the legal landscape around Mukherji v. Miller, the stronger the case you will be able to build. All right, now that you understand what's happening with EB1A approvals, the court challenges, and the shifting evidentiary standards, let's talk about what you actually do with this information. Here is a deeply practical 5-step action plan for your EB1A petition in 2026. Conduct an honest evidentiary audit with U.S. impact analysis before you file your EB1A. Sit down, ideally with a qualified immigration attorney who handles EB1A cases and understands the current adjudicatory environment, and go through the 10 EB1A criteria one by one. Don't just count how many you technically meet. For each criterion you claim, ask yourself 3 questions. Can I prove this with strong, credible, verifiable documentation? Can I show that my work has had genuine impact on my field, not just presence in it? And critically, can I demonstrate that my contributions have benefited or will benefit the United States specifically? If you cannot clearly articulate the U.S. impact of your work, you need to either gather additional evidence that demonstrates it, or develop a compelling narrative that connects your global achievements to American interests. Invest in quality expert opinion letters that speak to U.S. impact. In the current adjudicatory environment, expert opinion letters written by recognized leaders in your field have become essential for EB1A approval. But in 2026, these letters need to do more than praise your work generally. The most effective EB1A letters now explicitly address how the applicant's contributions have influenced American institutions, companies, research, or industry. If you can obtain letters from American experts, researchers at U.S. universities, executives at U.S. companies, leaders of U.S. professional organizations, who can speak to how your work has been applied or recognized in the United States, those letters carry significant weight. Generic letters from colleagues saying she's great at her job will not move the needle. Letters from independent experts who can speak to the field-wide significance of your contributions and their specific relevance to U.S. advancement are what USCIS is looking for. Build a U.S.-focused narrative for your EB1A, not just a credentials checklist. Your EB1A petition, particularly your cover letter and supporting brief, must tell a coherent, compelling story with America at the center. This doesn't mean fabricating connections that don't exist. It means strategically framing your genuine achievements in terms that resonate with USCIS's current priorities. Ask yourself, why does the United States benefit from granting me permanent residence? What will I contribute to American society, economy, technology, culture, or knowledge that would not happen if I were denied? How does my track record of achievement predict future contributions to America? USCIS officers reviewing EB1A applications are human. They read hundreds of petitions. A petition that clearly explains who you are, what you've done, why it matters to America, and what you will continue to contribute to the United States is far more persuasive than an internationally impressive CV without U.S. context. Monitor USCIS processing data, RFE trends, and court developments. The immigration landscape is changing rapidly. The USCIS website publishes processing time data. Immigration attorney communities actively track RFE trends in real time. Legal databases track court rulings like Mukherji versus Miller that may affect how your case should be framed. Staying informed about what USCIS is flagging in EB1A petitions in your specific field, technology, academia, arts, athletics, business, allows you to preemptively address those concerns in your initial filing rather than scrambling after an RFE. And if you receive a denial, staying informed about favorable court rulings gives you and your attorney ammunition for potential appeals or motions to reopen. Work with a licensed immigration attorney who understands the current EB1A landscape. This cannot be overstated. The EB1A is a complex discretionary legal petition. In an environment where USCIS is applying heightened scrutiny, where courts are actively challenging agency practices, and where evidentiary standards are shifting toward U.S. impact requirements, the quality of legal representation can be the determining factor in your outcome. An experienced EB1A attorney will understand not just the 10 criteria, but how USCIS is currently interpreting those criteria. They will know how to frame your evidence for maximum persuasive impact. They will be aware of recent court decisions that might benefit your case. And if things go wrong, they will know how to respond to an RFE effectively or pursue appropriate legal remedies. If someone is offering to file your EB1A for a flat fee of a few $100s with no attorney involvement, walk away. The consequences of an EB1A denial are real. They go on your immigration record, they affect future applications, and in some situations, they can have downstream effects on your status. So where does this go from here for EB1A applicants? That's the question I know many of you are sitting with. The honest answer about the future of EB1A adjudication is, there is genuine uncertainty, and anyone who tells you otherwise isn't being straight with you. What we know is that the current adjudicatory posture at USCIS for EB1A cases reflects institutional guidance that emphasizes rigorous review and demonstrable U.S. benefit. Those standards are unlikely to relax quickly, regardless of court challenges. The Mukherji v. Miller ruling is significant, but it applies directly only to that specific case. It will likely be appealed. Other federal courts may rule differently on similar challenges. The legal process takes time, months or years, and during that time, USCIS will continue adjudicating EB1A petitions under its current framework. If there is a circuit split, where different federal appeals courts reach different conclusions about USCIS's two-step framework, that could eventually push the issue toward the Supreme Court. But that timeline extends well beyond 2026 planning horizons. If Congress were to act for comprehensive immigration reform or targeted EB category legislation, that could alter the EB1A landscape significantly. But comprehensive immigration reform has been elusive for decades, and targeted EB category bills face significant political headwinds. What this means practically for EB1A applicants: plan for the standards as they exist today, not as you hope they might become. File the strongest possible case under current requirements, with explicit attention to U.S. impact evidence. Build in realistic timeline expectations. Processing times for EB1A I-140 petitions have ranged from several months to over a year, depending on premium processing and RFE issuance. And stay informed about legal developments. If you receive a denial, the Mukherji v. Miller precedent and similar rulings may provide grounds for challenge that didn't exist a year ago. Work with an attorney who understands not just the regulatory framework, but the evolving judicial landscape. I want to take a moment before we close to acknowledge something that data, policy analysis, and court rulings about EB1A can sometimes obscure. Behind every one of these EB1A petitions is a person, a family, a career built across years of work and sacrifice. Someone who came to the United States with a vision, who built something real, who wants to build a future here, securely, legally, permanently, through the EB1A green card. Your immigration status is not a bureaucratic abstraction. It affects your family unity, who you can bring here, who can stay with you. It affects your employment stability, whether you can change jobs, start a company, or take a risk on something new. It affects your financial security, your ability to buy a home, plan for retirement, invest in your future. And it affects your long-term residency and citizenship trajectory, the path to permanence that so many of you are working toward. That's why this EB1A update matters. That's why understanding the Mukherji v. Miller ruling matters. That's why the U.S. impact evidence requirement matters. That's why you need accurate, current information about EB1A approvals. And that's why I make these videos. Not to create fear, but to make sure you are never caught off guard by something you could have known.